Hello, hi, and welcome. In the previous session, we have seen a certain important topic about the subagent. Subagent, what is if a subagent is properly appointed with authority, and if a subagent is appointed without authority, in both the cases, what are the consequences that we have discussed in the previous topic, that is subagent. And now we will be discussing about substituted agent. Substituted agent. So, a substituted agent is a person appointed by the agent. Appointed by the agent to act for the principal in the business of agency with the knowledge and consent of the principal. So this will clearly tells a substituted agent is appointed by the agent, but to act for the principal, to act for the principal, and in the business of agency, but he is appointed with the knowledge and consent of the principal. So a substituted agent is appointed by the agent to act for the principal with the knowledge and consent of the principal in the business of agency. Right. So the question may come like this, dear students. Write about a substituted agent appointment. Right. And there is a likely chance of asking about what are the differences between a subagent and a substituted agent. You understand? So sometimes they may ask, write about a subagent and what are the differences between the subagent and a substituted agent. Sometimes they may ask, write about a substituted agent and what are the differences between the subagent and substituted agent. And there may be a chance that you may get a question asking straight away about the differences between the subagent and substituted agent. So before going to study the differences between the subagent and substituted agent, which will make your concepts very clear with regard to the technical differences between the two kinds of agents who are appointed again by the agent, right? So before going that, we will study a brief about a substituted agent. Substituted agents are not subagents. This point you need to remember. Substituted agents are entirely different from the subagents. Substituted agents are also appointed by the agent, whereas these substituted subagents are also appointed by the agent, but in some cases there is no consent or the now consent from of the principal for such an appointments. When it comes to a substituted agent, it is done with the knowledge and consent of the principal. So here the substituted agents works like agents of the principal, where the principal appoints an agent, and if that agent identifies another person to carry out the acts ordered by the principal, then the second person is not to be treated as a subagent but only as an agent of the original principal, right? So whenever there is a need to carry out certain acts by more than one agent, so the principal can appoint another person. In such a case, the other person will be called as an agent of the original principal. Let us see the relation between principal and person duly appointed by agent to act in business of agency, where an agent holding an express or implied authority to name another person to act for the principal in the business of agency. He named another person accordingly. Such a person is not subagent but an agent of principal. For such part of business of agency as entrusted to him. See, let us see an example for better understanding. A directs B, is a solicitor, B is a solicitor, right, to sell his estate by auction and to employ an auctioneer for the purpose. So B names C to appoint as an auctioneer to conduct the sale. So C is not a subagent. C is not a subagent but is A's agent for conduct of the sale. A's agent. Right. So A's agent for conduct of the sale. And agent's duty in naming such person. What is the duty of agent? To show C to Mr. A as a agent to conduct the sale. So in selecting such an agent for principal, an agent is bound to exercise the same amount of discretion as a man of ordinary prudence would exercise in his own case. And if he does this, he is not responsible to the principal for the acts or negligence of the agent so selected. So this is the small duty of an agent while recommending someone else to get appointed as an agent to carry out some acts under the contract of agency. So he should act as a man of ordinary prudence. Who is to act as a man of ordinary prudence? The agent who is naming someone as an agent to act on certain transactions should use his discretion to select the name of some other person to recommend to the principal to appoint as an agent, like a man of ordinary prudence would exercise in his own case. And if he does this, he is not responsible to principal for the acts or negligence of the agent so selected. Right, students? And now we will go to the differences between a subagent and a substituted agent. So if you understand this, then you will better appreciate it. Right. When it comes to the difference between subagent and the a substituted agent, here, both the subagent and substituted agents are appointed by the agent only. But however, the following are the some of the points of distinction between the two. So let us see what is the first point of distinction between the subagent and substituted agent. A subagent does his work under the control and directions of agent. Right. Here, in case of a subagent, he will work under the control and directions. Control and directions of the agent is the guiding force behind the subagent. When it comes to a substituted agent works under the instructions of the principal. See how nicely given the first point of difference between a subagent and a substituted agent. A subagent, he takes his directions and control from the agent. A substituted agent, he works under the instructions of the principal. That is the difference. You know that agent and principal are the two parties to a contract of agency, and subagent works under the agent control and directions, and substituted agent works under the instructions of the principal. And the second point of difference between the subagent and substituted agent, and in case of a subagent, agent not only appoints a subagent but also delegates to him a part of his duties. Right here, you see that an agent will delegate some of his duties to the subagent. And when it comes to a substituted agent, agent does not delegate. Agent does not delegate any of his tasks or duties to substituted agent. Right. So here you know that in both the cases, though the subagent and substituted agent is appointed by the agent, when it comes to the second point of difference, a subagent will be delegated some of the tasks of the agent. When it comes to a substituted agent, there is no delegation of the tasks of the agent to substituted agent. Here, the substituted agent will have a separate duty, separate task, which was given by the principal, right? So here, agent in the contract of agency, an agent do not have a right to delegate his duties. So here, in case of a sub-agent, there is a delegation. But whereas in case of a substituted agent, there is no delegation of duties of agent to the substituted agent. The third point of difference, there is no privity of contract. So the legitimacy of contract will not be there between the principal and the subagent, right? So in case of a subagent can be will be appointed by the agent without the knowledge and consent of the principal. So that is why there is no privity of contract between the principal and subagent. There is no privity of contract between the principal and the subagent. When it comes to a substituted agent, there is a privity of contract between the principal and substituted agent. The fourth point of a difference is the subagent is responsible to the agent alone, right? So to the agent alone, the subagent is responsible, and he is not generally responsible to principal. Here, student should remember, not generally responsible. The reason is that if the sub agent is appointed with the consent of the principal, in such a case, or if the appointment of sub agent if at a later date ratified by the principal, so in such a case the principal will have a responsibility for the actions done by a subagent. Otherwise a subagent is not generally responsible to the principal. A substituted agent is responsible to the principal. A substituted agent is responsible to the principal because he is appointed with the consent and knowledge of the principal, and he is not responsible to the original agent who appointed him. Though a substituted agent is appointed by the agent, he is responsible to the principal but not to the original agent. And the fifth point of difference is the agent is responsible to the principal for the acts of a subagent. So it is the agent who is responsible to the principal for the acts of subagent. The reason is that you know that here, in case of a sub-agent, the agent has delegated some of his duties to the sub-agent, so which he should not do, and because of that reason, all the acts of sub-agents will make the original agent to responsible to the principal. And when it comes to a substituted agent, the agent is not responsible to the principal for the acts of substituted agent. So as long as the agent recommends the name of the substituted agent to principal for appointment, like a person of an ordinary prudence without any negligence, in all such cases, the agent is not responsible to the principal for the acts of the substituted agent. And the sixth point of difference is the subagent has no right of action against the principal for remuneration due to him, because the subagent is appointed by the agent, and original agent has delegated some of his duties to subagent. As such is the case, the subagent and the principal do not have any privity of contract. As there is no privity of contract between the subagent and principal, as such, the subagent has no right of action against the principal for remuneration due to him. In case of a substituted agent, he can sue the principal for remuneration due to him, right? Because the substituted agent is appointed by the agent with the consent and knowledge of the principal, and here the substituted agent is worked as per the instructions of the principal. Hence there was a privity of contract between the substituted agent and the principal. As such, all these are giving rise to demand the remuneration due to him from the principal by a substituted agent. Understand the point, dear students. It is a beautiful distinction of points between the subagent and substituted agent. If you are able to understand the distinction between these two, you will be able to write any question. You will be able to give a judgment on any type of questions that may likely to come in your examination with respect to a subagent or a substituted agent, right? The next point of difference is a subagent may be improperly appointed, right? A subagent may be improperly appointed. Improper appointment means appointment of a subagent by the agent without the consent or knowledge of the principal is a improper appointment. Whereas when it comes to a substituted agent, can never be improperly appointed, can never be improperly appointed by the agent. The reason is that the appointment of substituted agent is done with knowledge and consent of the principal, and the substituted appointment will work with the instructions of the principal, and there was a privity of contract between the substituted agent and the principal, right? And the eighth point of distinction is that the agent remains liable for the acts of subagent as long as the subagency continues. The agent remains liable. The agent remains liable for the actions of the subagent to the principal as long as the subagency is continued. The reason is that it is the agent who delegated some of his duties to the subagent to carry out without the consent of the principal. So that is why it is the agent who remained liable to the principal for the actions of the subagent. And when it comes to a substituted agent, the agent's duty ends. The agent's duty ends once he has named the substituted agent to the principal, so that the principal will give him instructions to do certain work, and there arises a privity of contract between the principal and the substituted agent, so that the agent who is originally naming the substituted agent to the principal is no longer have any kind of liability for the actions done by the substituted agent under the contract of agency. Right? Right. These are the eight beautiful and very nice distinctions that are given with respect to a subagent and a substituted agent. Dear student, I am telling you again and again, I am telling you that you have to be very thorough with regard to the subagent and substituted agent, where it is the likely source of area where the examiner would likely to pick a question in your final examinations. Right. The next important question possible is the duties and obligations of agent in contract of agency. See, what are the duties that are being there to an agent in the contract of agency is an excellent and fantastic topic for the question in our examinations. There are about nine duties that are being given in our course content with regard to the duties and obligations of an agent. So the first duty, you see, this is a beautiful flow diagram which was given and will be very easy for you to memorize, recall the duties of an agent under the contract of agency. The first duty is duty to execute mandate. Duty to execute mandate. Mandate means a set of instructions which are given by the principal to the agent. It is the first duty of an agent to execute. And the second is that conduct the business in accordance with the directions given by the principal from time to time. So, if the agency is to conduct a business, and it is the duty of the agent to conduct that such a business as per the instructions and the directions given by the principal. The third, the third duty of a agent in the contract of agency is a duty of reasonable care and skill. While discharging his duties, as an agent, it is the duty of the agent to exercise reasonable care and apply the reasonable skill without any negligence, like a person of ordinary prudence. You understand? So it should be like that. And the fourth duty is duty to communicate with the principal. What to communicate with the principal? With respect to the execution of the duties that are being, or with respect to the instructions that are given under the contract of agency, whatever the terms and conditions are there, all these happenings are to be keep on communicated and updated to the principal by the agent. The reason is that it is the principal who is responsible to the, or who is liable to the third parties under the contract of agency. So that is the reason all the developments of the business should be communicated in time to the principal by the agent as a matter of duty. Understand? So the next is a duty to avoid conflict of interest. So he should not create any conflict of interest while discharging his duties. And the next one is a duty not to make any secret profits. This is the one dangerous zone where it is very, very difficult for the principal to manage the affairs of the agent. So Always the agent should not try to make secret profits. However, it is the source for the agents to make secret profits, and it is in many cases it is very difficult for a principal to curtail the area of making the secret profits. However, the contract of agency imposes a duty on the agent not to make any secret profits out of the contract of agency. Whatever the profits are there, that should be known to the principal. And a duty to remit sums. So whatever that comes to the agent and whatever he collects on behalf of the principal from the different third parties, and all these sums are to be remitted back to the principal. And duty to maintain accounts. So in case of a trade or business or performing some work, and whatever the receipts and the payments that happens, all those things are to be recorded in the form of accounts, and it should be maintained by the agent, which has to be submitted back as and when called for by the principal. And that last duty is a duty not to delegate. This is the one point. No agent has a right to delegate his duty to any other person. So that is the last duty, and there are about nine beautiful duties that are given under the duties and obligations of an agent. So this is a fantastic question. If it comes for 5 6 marks, if you are able to write some three sentences about with each duty that is given here, that will be a very appealing answer to the paper evaluator to award full marks. And let us go little in detail with respect to various duties that we have discussed in the above flow chart. So the first duty is a duty to execute mandate. The first and foremost duty of every agent is to carry out the mandate of the principal, to carry out the mandate of his principal. He should perform the work which he has been appointed to do. Any failure in this respect would make the agent absolutely responsible for principal's loss. So this is about the duty to execute mandate by the agent, right? The agent was under instruction to to act accordingly. So he has to do as per the mandate given by the principal. The second duty is a duty to follow instructions and customs. According to section 211, an agent is bound to conduct the business of his principal according to the directions given by the principal, or in the absence of any such directions, according to the customs which prevails in doing business of the same kind at the place where the agent conducts such business. When the agent acts otherwise, if any loss be sustained, he must make it good to his principal. So the agent must make it good to principal, and if any profit accrues, he must account for it. And if he makes any profit out of it, he must account for it and should disclose and remit it back to the agent, sorry, principal. Let us see an example for your best understanding. A, an agent engaged in carrying on for B a business. A is an agent, so in which it is the custom to invest from time to time at interest the monies which may be in hand, and omits to make such investment. As a result, A must make good to B the interest usually obtained by such investment. Right. So here agent is being appointed in the business of B, and whatever the surplus money is there with Mr. A, who is an agent, it is the duty of him to invest the surplus money in order to get the interest. And when A fails to make an investment, and whatever the loss of interest that happens to Mr. B in that business because of not investing the surplus money in the interest, in investment to get interest, all that are to be make good to B. So it is the duty of agent to compensate Mr. B, who is a principal in this regard. You understand? So the following of the instructions of the principal and the customs that are prevailing in the business should be complied by the agent without fail. And if he does not comply, and if any loss happens in all such cases, the agent has to compensate the principal. And the third duty to reasonable care, duty of reasonable care and skill. According to section 212, an agent is bound to conduct the business of the agency with as much skill as is generally possessed by a person engaged in similar business, unless the principal has a notice of his want of skill. The agent is always bound to act with reasonable diligence and to use such skill as he possesses, and to make a compensation to his principal in respect of the direct consequences of his own neglect, want of skill, or misconduct, but not in respect of loss of damage which is which are directly or remotely caused by such neglect, want of skill, and misconduct. Right? So this is about duty of reasonable care and skill. And let us see an example for your understanding. A merchant in a Calcutta has an agent. A merchant in Calcutta has an agent, and B in London, to whom a sum of money is paid on A's account, with orders to remit, and B retains the money for considerable time. A, in consequence of not receiving the money, becomes insolvent. B is liable for money and interest from the day on which it ought to have been paid, according to the usual rate, and for any further direct loss, example by variation of rate of exchange, but not further. So here, whatever the reasonable care and skill is to be exercised is not exercised, hence the agent is required to compensate the principal for the loss of interest and for not doing his duty with care and reasonable skill. So this is the third duty. And the fourth one is the agent's duty to communicate with the principal. It is the duty of an agent in case of difficulty to use all reasonable diligence in communicating with his principal and in seeking to obtain his instructions. Next one is a duty to avoid a conflict of interest and right of principal when agent deals on his own account in business of agency without principal's consent. See here, if an agent deals on his own account in the business of the agency without first obtaining the consent of his principal and acquiring him with all material circumstances which have come to his own knowledge on the subject, the principal may repudiate the transaction if the case shows either that any material fact has been dishonestly concealed. Any material fact, if dishonestly concealed, by the agent, or that the dealing of the agent have been disadvantageous to the principal. In all such cases, the agent's duty to avoid a conflict of interest. Let us see an example for your understanding. A directs B to sell A's estate. So here A is the principal, B is the agent. B buys the estate for himself in the name of C. See here what happened. B, instead of he was being appointed to sell the estate of A, but what B did is that B buys the estate for himself in the name of C. Right. On discovering that B has bought the estate for himself, may repudiate the sale if he can show that B has dishonestly concealed any material facts or that the sale has been disadvantageous to the principal. Normally, what happens when agent himself is buying for himself, if the cost of that estate is 100 crores, he would say that market price of particular estate is say some 80 crores, and he will buy that for 80 crores. After a year or so, he can sell it the same for 100 crores. A margin of 20 crores he can dishonestly acquire by concealing the material facts to Mr. A, who is the principal. This example will explain you very better. So, not to create any conflict of interest by the agent while executing the duty given to him under the contract of agency. And the next duty is a duty to make a duty not to make secret profits. It is the duty of an agent not to make any secret profits in the business of agency. His relationship with the principal is fiduciary in nature. Fiduciary in nature means in good faith, and this requires absolute good faith in the conduct of agency, right? And the next duty is a duty to render proper accounts. An agent is bound to render proper account to his principal on demand. Rendering accounts does not mean showing the accounts, but the accounts are supported by the vouchers. The next duty is that duty not to delegate. Duty not to delegate. An agent cannot lawfully employ to perform acts which he has expressly undertaken to perform personally, unless by the ordinary custom of trade a subagent may or a subagent must be employed. Right. The ninth one is that agent's duty to pay sums received for principals. The say subject to such deductions, the agent is bound to pay to his principal all sums received on his account, and a duty not to use any confidential information received in the course of agency against the principal. So this 10th point was not given in your flow chart, dear students. You just make a note of it. So the confidential information received in the course of agency shall not be used against the principal by the agent. That is the duty of the agent. So the next important topic is here, rights of an agent. Rights of an agent. There are about 5 rights to an agent under the contract of agency that we will see it. Right of retain out of sums received on principal's account. Right of retaining out of sums received in principal's account. So the section empowers the agent to retain out of any sums received on account of principal in the business of the agency for the following payments. All monies due to himself in respect of advances made, in respect of expenses properly incurred by him in conducting such business, such remuneration as may be payable to him for acting as agent. The right can be exercised on any sums received on account of principal in the business of agency. The next right is that a right to remuneration. The agent in the normal course is entitled for remuneration for the contract. In the absence of any agreed amount of remuneration, he is entitled for usual remuneration, which is a customary in the business. However, an agent is guilty of misconduct in the business of the agency is not entitled to any remuneration in respect of that part of the business which he has misconducted. Right. So the next third right of an agent is to exercise lien on principal's property. In the absence of any contract to the contrary, an agent is entitled to retain the goods, papers, and other property, whether movable or immovable, of the principal received by him until the amount due to himself for commission, disbursement, and services in respect of the same have been paid or accounted for him. Right. And the fourth right is the right to indemnity. So when it comes to right to indemnity, it is of a different kinds as well. Right of indemnification for lawful acts. The principal is bound to indemnify the agent against all consequences of lawful acts done in exercise of his authority. Right. The second one is the right of indemnification against acts done in good faith. So whether the agent acts in good faith on wherever the agent acts in good faith on the instructions of principal, agent is entitled for indemnification of any loss or damage from the principal. And the third kind of indemnification is non-liability of employer for agent to do criminal act. Non-liability of employer of agent to do criminal act. According to section 224, where one person employs another to do an act which is criminal, the employer is not liable to the agent either upon an express or implied promise to indemnify him against the consequence of that act. And the fourth right here, after indemnification, the fourth right is a right to compensation of injury caused by principal's neglect. Section 225 provides that the principal must make a compensation to his agent in respect of injury caused to such agent by principal's neglect or want of skill. Thus, every principal owes to his agent the duty of care not to expose him to unreasonable risk. These are the five rights that are being given about the rights of an agent, and which is very, very important. And the question sometimes may be asked, what are the rights and liabilities of an agent? And now we discussed about the rights as a separate topic. Now we will look at the agent's liability to third parties. In fact, agent's liability to the third parties is insignificant because it is the agent who is a link between the principal and the third parties. Here, agent works as a link, and once the privity of contract arises between the third party and the principal, agent is no longer have any liability to the third parties. And even then, there are certain legal provisions with respect to agent's liability to third parties that we will look at it. An agent does all acts on behalf of the principal but incurs no personal liability. See here, he does not incur any personal liability. The liability remains that of the principal unless there is a contract to the contrary. So, unless there is a contract that you, agent, who you are going to be liable to the third parties, otherwise, in all such circumstances, it is the principal who will be liable to the third parties. This is because there is no privity of contract between the agent and the third parties. Why the agent is not liable to the third parties? Because there is no privity of contract and passing of consideration between the agent and the third party. An agent also cannot personally enforce contracts entered into by him on behalf of the principal. Right? So now the first one, agent's liability to third parties. Principal's liability for the acts of the agent. Principal's liability for the acts of the agent. Principal liable for the acts of agents which are within the scope of his authority. Contracts entered into through an agent and obligations arising from the acts done by an agent may be enforced in the same manner and will have the same legal consequences as if the contracts had between entered into and the acts done by the principal in person. Right. So for all the acts of the agent, it is the principal who is liable to the third parties, like that of the principal is doing directly something with the third parties. Let us see an example where your understanding will be fortified. A buys goods from B, knowing that he is an agent for their sale. A buys goods from B, knowing that he is an agent for their sale, but not knowing who is the principal. B's principal is the person entitled to claim from A the price of the goods. B's principal is the person entitled to claim from A who purchases. A is the third party here, and B is the agent, and it is the principal of B who will be receiving the price of the goods, and A cannot in a suit by the principal set off against that claim a debt due to himself from B, which mean to say that A, the third party, cannot suit by the principal set off against that claim a debt due to himself from B. Right. So A, he cannot set off the debt claim which is due from an agent in that particular transaction, because the transaction is happening between A and the B's principal, not between A and B. If there is anything to be set off because the B is owing something to A, that will not work here. It should not be done. So it is the principal's liability for the acts of the agent, which keeps a privity of contract between the principal and the third party. And see, the next liability to third parties is that principal not bound when agent exceeds authority. In the contract of agency, an agent will be given some authority to carry out the assignment. And if the agent exceeds the authority given by the principal for the acts of the agent which are beyond the authority of the agent, for all such acts, it is the agent who is responsible to the third parties but not the principal. See, let us see under section 227, when an agent does more than he is authorized to do, and when the part of what he does which is within his authority can be separated from the part which is beyond his authority, so much only of what he does as is within his authority is binding as between him and his principal. So if he do anything beyond the authority, that will not bind the principal to the third party, and whatever the agent do within the authority, for all such acts he can make the principal liable to himself and as well as the third parties. And the next is a principal not bound when excess of agent's authority is not separable. Right. Principal is not bound when excess of agent's authority is not separable. If the agent exceeds his authority, and if it is not separable, in all such case, for the entire transaction, the principal is not bound. Where an agent does more than he is authorized to do, and what he does beyond the scope of authority cannot be separated from what is within it, the principal is not bound to recognize the transaction. The principal is not bound to recognize the transaction. And the next one is the consequence of notice given to agent. The consequence of notice given to agent. Any notice given to or information obtained by the agent, provided it be given or obtained in the course of business transacted by him for the principal, shall, as between the principal and the third parties, has the same legal consequence as if it had been given to or obtained from the principal. See, consequences of notice given to an agent will work like that. And the next one is agent cannot personally enforce contracts on behalf of principal. Right. So, in the absence of any contract to that effect, an agent cannot personally enforce contracts entered into by him on behalf of his principal, nor he is personally bound by them also. He can neither sue nor be sued on contract made by him on his principal's behalf. So there are certain presumptions of contract to the contrary. So that presumptions we will have a look at it. Such a contract shall presumed to exist in the following cases. The first is that where the contract is made by an agent for the sale or purchase of goods for a merchant resident abroad or foreign principal. And second case is where the agent does not disclose the name of his principal or undisclosed principal or unnamed principal. And the third is that non-existent or incompetent principal, where the principal, though disclosed, cannot be sued. So, in all such cases, agent cannot personally enforce a contract on behalf of principal, and the presumption of contract to the contrary is these three cases. And the sixth rights of parties to contract, rights of parties to a contract made by agent not disclosed. Right. Rights of parties to contract made by agent not disclosed. If an agent makes a contract with a person, if an agent makes a contract, agent makes a contract with a person who neither knows nor has reason to suspect that he is an agent, his principal may require the performance of the contract. But the other contracting party has, as against the principal, the same right as he would have had as against the agent if the agent had been the principal. So, this is about the duty of a third party against, the right of a third party against the agent. The seventh one is a performance of contract with agent supposed to be principal. Performance of contract with agent supposed to be a principal, where one man makes a contract with another neither knowing nor having a reasonable ground to suspect that the other is an agent. The principal, if he requires the performance of the contract, can only obtain such performance subject to the rights and obligations sustained between the agent and the party to the contract. Right. So far we have covered about the seven areas where the agent's liability to the third parties will be come into picture. And the eighth point is that where the liability of an agent to third party is been reflecting right of person dealing with agent personally liable, right of a person dealing with the agent personally liable. If a third party, if he directly deals with the agent, and the personal liability will come into picture. In case where the agent is personally liable, a person dealing with him may hold either him or his principal or both of them liable. See here. So whenever a third party is dealing with the agent, he has a right to sue either the agent or the principal, or both the agent and principal are liable for this. Let us see an example in this regard. A enters into a contract with B to sell him 100 bales of cotton. A enters a contract with B to sell him 100 bales of cotton, and afterwards discovered that B was acting as an agent for C. Right. Here A is the third party, B is the agent, and later the third party A comes to know that B was acting on behalf of C. C is the principal. So the third party, who is A, may sue either B, which means to say agent, or C, who is a principal, or both, which means to say he can sue both B and C, or for the price of the cotton. Right. So the ninth one is a consequence of inducing agent or principal to act on belief that the principal or agent will be held exclusively liable. When a person who has made a contract with an agent induces the agent to act upon the belief that the principal only will be held liable, or induces the principal to act upon the belief that the agent only will be held liable, he cannot afterwards liable the agent or principal respectively. See here, the third party is inducing either the agent or the principal. So when you induce any of the parties to a contract, then later you cannot hold liable either the principal or the agent for that particular transaction is concerned. So third party cannot exercise any right against neither the principal nor the agent. And the ninth point is saying about the liability of a pretended agent. A pretended agent is a person who represents himself to be an agent of another. So, say for example, A is a person, though he is not an agent of some principal, he pretends that he is the agent of some other person. So when in fact he has no authority for him whatsoever, if the principal ratifies his acts as agent, he has no liability. So for whatever the pretended agent is doing with the third parties at a later date, the pretended agent's actions were ratified by the principal. In such a case, the agent will not have any liability towards third parties. It is the only principal who will have a liability. But the pretended agent's actions, if not ratified at a later date by the principal, in all such cases, it is the pretended agent who will be liable to the third parties, but not the principal. Right. And when it comes to the 11th point, persons falsely contracting agent not entitled to performance. A person with whom a contract has been entered into character of agent, in the character of agent, he is not entitled to require the performance of it if he was in reality acting not as agent but on his own account. So there is a undue way of dealing the transaction by the agent. As such, the third party cannot make the principal bind for that particular action. And the 12th point is that the liability of principal inducing belief that agent's unauthorized acts were authorized. See here, if the principal is inducing a belief that agents' other unauthorized acts are authorized, in such a case, it is the principal who will be liable, obviously. When an agent has, without authority, done acts or incurred obligations to third persons on behalf of his principal, the principal is bound by such acts or obligations if he has, by his words or conduct, induced such a third person to believe that such acts and obligations were within the scope of the agent's authority. When principal behaves like that, the agent is having the authority while dealing with the third parties. So normally the third party will have a right to sue the principal because he gave an impression that the agent has a right to act on his behalf, though it was unauthorized, but he gave a signal that for that act there is an authority. So it is the principal who is responsible and liable to the third parties. And the last one is here about effect on agreement of misrepresentation or fraud by agent. Misrepresentation made or fraud committed by agents acting in the course of their business for their principals have the same effect on the agreements made by such agents as if such misrepresentations or frauds had been made or committed by the principals. Right, but misrepresentations made or frauds committed by agents in matters which do not fall within their authority do not affect their principals. So this is the point you need to remember. If the misrepresentations, if the but if misrepresentations made or frauds committed by agents in matters which do not fall within their authority do not affect the principles, and if it comes within the authority of the agent, if any fraud or misrepresentation is done by the agent, in all such cases it is the principal who is responsible and liable to the third parties. And these are the 13 points. These are the 13 points that is very important in your examinations with respect to the agent's liability to third parties. Though here this topic is saying that the agent's liability to the third parties, in most of the cases it is the principal who is liable to the third parties as long as the agent acts within the authority given to him. That is the point a student has to remember, so that you can very easily comprehend and understand, and would be able to write all these 13 points. And now we are going to the last topic. It is a revocation of authority. And what are the modes of termination of agency? How an agency can be terminated when a agency is irrevocable, and what are the effects, duties of agent upon termination of agency. I just would like to give a just a gist of it, because the session is going a very long time and will be difficult for a student to keep on understand the various new concepts. So the termination of agency can be possible by revocation, which mean to say, say an agency may be terminated by a principal, revoking the authority of agent. Once the agent's authority is revoked, automatically the contract of agency will get terminated. And the second one is renunciation by agent. An agent may renounce the business of agency, and if the agent gives up the business in the manner in which the principal has a right to revoke it, in such a case also the business of agency will be get the contract of agency will get terminated. It is revocation if it is come to an end through by the action of the principal. It is called as a renunciation if it is from the side of the agent, if the contract of agency is gets terminated. And the third is that the completion of business. If the business is completed for which the contract of agency is made, then automatically agency will be come to get terminated. And the fourth one is a death or insanity. An agency is determined automatically on the death or insanity of either the principal or the agent, and then automatically the contract of agency will get terminated. The fifth way of termination of contract of agency is the principal's insolvency. An agency ends on principal being adjudicated insolvent. Sixth one is on expiry of time. Once the time of that contract of the agency is over, it will get terminated. Where an agent has been appointed for a fixed term, the expiration of the term puts an end to the agency. Whether the purpose of agency has been completed or not, an agency comes to an automatic end on expiry of its term. So, dear students, these are the six ways of making a contract of agency terminated. So, with this, your unit 3 with regard to agency is complete. This is a very important unit in the first chapter, the third unit, which is agency, because it is the a kind of source for the modern day business. And many budding entrepreneurs are coming into the business fold by taking agency of one or the other business, and they are having the livelihood. As such, this is one important chapter where your knowledge will help yourself to give good advice back to your clients once you become professional. And with this, I thank you one and all for listening patiently the lengthiest session. I wish you all the best.